My session today is going to be focusing on a topic which some of the other speakers have touched briefly upon. And I thought best to devote this little time that we have to one topic exclusively and go into it in some detail. And in some ways, the themes of my presentation are very similar to the themes raised by Daniel and Harnik in their presentation. But the focus is more on 3D and less on US law. Now, at the outset, this has been a question which has been cropping up time and again. And that question is whether 3D actually covers what we would normally call a new chemical entity. Now, many of you who are from the pharmaceutical space will know the definition of a new chemical entity. It is a chemical compound which is defined by chemical bonds between molecules. So salt, for example, is not a new chemical entity because the bond between the molecule and the salt ion is not as such a chemical bond. Now, you also know that there is an explanation appended to 3D. And that explanation defines specific, very specific subject matter. Now, the explanation itself, of course, or 3D is not limited to the categories of subject matter which are defined in the explanation for the simple reason that, established principles of statutory interpretation would lead you to conclude that there could be other things which are also covered by 3D apart from what is mentioned in the explanation. Now, if you do look at the specific subject matter that is mentioned in the explanation, I find at least 3 categories of subject matter which are actually NCEs. For example, the explanation mentions esters, it mentions ethers, and it mentions metabolites. All these 3 are new chemical entities. And by analogy, if it mentions metabolites, then by analogy it could also be extended to prodrugs, because prodrugs and metabolites are very similar in a pharmacological sense. Now, apart from that, of course, the question of whether an isomer can be defined as an NC or not is still up in the air as far as the FDA is concerned. But as of now, the FDA does treat an isomer as a complete, as an NCE, which requires a full clinical trial. So therefore, from the regulatory perspective at least, an isomer is a new chemical entity. But from a structural perspective, because it shares the same structural features as the racemic compound, I wonder whether it could be called an NC in pure chemical terms. Now, apart from that, the explanation also mentions other derivatives. Now, what does this other derivatives mean? Derivatives is a term which is unfortunately used very loosely in pharmaceutical patents. And a derivative could mean almost anything. So it would not be surprising to me if a derivative were to also cover a compound which is a completely different compound, or in other words, an NC. But then the question, of course, that you have to ask is, where do you draw the line? Does that mean that every single new chemical compound is precluded by reason of falling under 3D? No. So that's the first point that I wanted to address. Now, the second point is, are we reading too much into 3D than what is actually there and the practice or the standards that we have in other countries? Now, is 3D really that much different from US law? If we look at 3D and compare it, for example, to the US law, then one important difference that immediately strikes you is that 3D, of course, is a statutory rule. And it's a per se rule, in the sense that the explanation mentions certain subject matter, such as salts, polymorphs, etc., whereas in the US, the patentability of the same subject matter, which is mentioned in 3D, has evolved through case law. So therefore, you can say that it's statutory, it's a per se rule, and that's one difference between the US and India as far as defining patent-eligible subject matter is concerned. And I'd also like to just here mention that 3D defines what is globally known as patent-eligible subject matter, not patentable subject matter. And in that sense, 3D is analogous to Section 101 of the US Patent Act. So there are separate provisions in the Indian Patent Act which define when an invention is patentable, but 3D is not such a provision. It defines patent-eligible subject matter. And though it might be called a per se rule, there is an additional test to be employed, which is embodied within the provision. Namely, that if any of these categories of subject matter does exhibit enhanced efficacy, then obviously 3D does not preclude that from being granted a patent. That much is very clear. Now, if you look at countries such as the US, just taking the US as an example, because I'm obviously more familiar with US law than I am with European law, for example. Now, I think as long as there has been a patent law in the US, the courts have tended to define categories of things which are not eligible subject matter for patents. So though nothing by itself is mentioned in Section 101, the requirement to define patent-eligible subject matter does flow from 101. And I think you have to go back to understand the current US position on what is and what is not patent-eligible subject matter in the US. You have to go back to that trilogy of cases, sometimes known as the algorithm exception cases. The trilogy is Gottschalk versus Benson, Parker versus Fluke, and Diamond versus Derrer. And that's exactly what the Supreme Court has recently said in its recent decisions in Bilski and Mayo as well. Now, I think Daniel spoke about the Mayo case. And I think what the Supreme Court is saying here is that while a natural law is not patentable, and this has been a consistent standard employed in the US right from the beginning, the application of that law may indeed be granted a patent, but not where the application of that law is routine and conventional. So if you look at the facts of the Mayo case, it's very clear that the method of monitoring the blood levels of metabolites in a patient before determining an appropriate dose of the drug was something which is considered extremely standard in the United States and elsewhere as well, because for the simple reason that some drugs can lead to increased toxicity, and some patients may be more susceptible to that toxicity than other patients. And therefore, it is obviously important to first determine what reaction that drug is causing by testing the blood sample of a patient before deciding to titrate the drug upwards or downwards. So, because I think this method was entirely routine and conventional, I think that led the Supreme Court to conclude that this patent, in fact, defined subject matter which was not eligible for a patent. Now, if you look at the subject matter which is defined in 3D, in section 3D. And for example, if you look at polymorphs, or if you look at salts, now these have all been the subject of decisions by the Federal Circuit and the US Supreme Court. Now, how is 3D subject matter dealt with by the US courts? Obviously, under the rubric of prior art and under the rubric of patentability, not under the rubric of patent eligible subject matter. But if you look at the US, even the US has had at one time or the other per se rules with respect to certain specified categories of subject matter. For example, if you look at the Haas-Hens doctrine, that defined a per se rule with respect to homologs. If you look at In re Me, which was decided in 1977, that defined a per se rule with respect to isomers. So how different is it when you compare the situation where a court lays down a per se rule which says that an isomer or a homolog cannot be patented, and how different is that with 3D, which says in the statute that an isomer or a homolog or a metabolite is prima facie unpatentable. You've also had cases like Schering versus Geneva, where metabolites have been held unpatentable on the ground of inherent anticipation. The same in the case of polymorphs, in the case of SmithKline versus Apotex, where the court held that a polymorph which was claimed in a patent was inherently anticipated by the practice of the prior art. So you have these decisions, it's true, flowing from, on a case-to-case basis, from judgments of the courts, as opposed to 3D, which lays it down in statute. But how different really is it in practice? Because with respect to everything that would be considered prima facie unpatentable in the US, a patent can actually be obtained if you are able to demonstrate unexpected properties with respect to what you are claiming. And that's exactly what 3D is saying. 3D is saying that if you can demonstrate enhanced efficacy with respect to a polymorph or a salt, then you can in fact get a patent for it. So in practice, I don't think the US standard is much different from the Indian standard. Of course, having said this, I must confess that the definition of unexpected properties in US law is much broader than what we would define as enhanced efficacy in 3D. Enhanced efficacy obviously relates only to the therapeutic effect that a molecule produces, whereas obviously enhanced or unexpected properties obviously runs the whole gamut of any surprising result that can be produced by a product in comparison with the prior art. So I do, think that it's time to look at what 3D actually does in practice and how different India is from other countries in the world. And if there's not much difference, I don't think we should make too much of a fuss if 3D is there on our statute books or not.